Attorney General.
Thank you very much, Mr. Vice President. And I will ask you to allow for the fact that my voice is not what it ordinarily is. And I shall try to be brief. Mr. Vice President, I am very pleased and I'm proud to stand here today to support this Property Tax Amendment 2024 and to applaud the Minister of Finance for having, on behalf of the government of Trinidad and Tobago, listened to the concerns of citizens of this country. The reality, Mr. Vice President, is that tax is not something that anybody likes to pay. It's as simple as that. In point of fact, I did a little bit of research and, not unsurprisingly, found that tax was first introduced, if I'm not mistaken, in the year 3000 BC in ancient Egypt. And the reality, Mr. President, Mr. Vice President, is that all countries have a tax system in place in order to pay for public, common, societal, or agreed national needs and for the functioning of government. All countries. And it affects each of us at different levels, and it affects each of us at a level which always brings with it a measure of pain. But we have to recognize, and in particular in this House, that we are legislators. We have to put the histrionics aside. And we have to look to join hands to determine what serves the common good. This piece of legislation is the most recent amendment. It is the 6th amendment to the property tax, which was passed in 2009, took effect on the 1st of January 2010. And there have been 5 amendments before this. And very importantly, the amendment made by the Finance Act 2023 brought into effect, among others, Section 33 to allow the municipal corporations to collect tax by order of the minister, so that the tax that is collected through this medium can be put back directly into the communities for the community good, and to streamline the laws in other respects. Mr. President, this particular piece of legislation, this bill, it's very short. The Minister of Finance has spoken to it in detail. It really consists of Clause 2 and Clause 3. Clause 2 introduces a new Section 17A, which effectively grants or seeks to grant an extension of time within which the notice of assessment will be issued. It takes it to the 30th of June 2024. Otherwise, we would be saying we are going to remain with the current time frame that takes us 6 days away to the 31st of March. What's wrong with that? The other part of the amendment, which has been introduced, Mr. Vice President, is the repeal of the existing Section 52 of the Act, so as to substitute Section 31 of the Valuation of Land Act, and by that process to make clearer the process by which, if any act or anything required to be done at or within a fixed time under this Act cannot or is not so done, the President may by order from time to time appoint a later time for doing those things to be done under the Act. I don't need to read the whole section, but it is to simplify and make more administratively facilitative the application of the Act. And then we have the further amendment, which always arouses a significant degree of histrionics from Senator Mark, and that is to change the affirmative to the negative resolution. And I'm going to spend a little time on that when I get there, because I think we need to understand more clearly what is the difference between an affirmative and a negative resolution, and why, in the context of this particular piece of legislation, it makes sense. And then the other amendment that is being brought is, Mr. President, to bring into effect the effective date. But let me spend a little time on Section 75 in relation to the affirmative and negative resolution. Section 75 of the Interpretation Act, Mr. President, reads, "The expression subject to negative resolution of Parliament when used in relation to any statutory instrument or statutory documents means that those instruments or documents shall, as soon as may be after they are made, but within the prescribed time, be laid before each House of Parliament." I emphasize that, be laid before each House of Parliament. Where either House, I'm still reading, quoting from Section 75 of the Interpretation Act, where either House within the prescribed period resolves that any of those instruments or documents shall be annulled, that instrument or document is void as from the date of the resolution, but without prejudice to the validity of anything done thereunder or to the making of a new instrument or document. Now, Mr. Vice President, that piece of legislation, that is to say, the Interpretation Act is not all that one takes into account when you are understanding the operative effect of a negative resolution. You then also have to have regard, Mr. President, to the Statutes Act, Section 12(1)(a) of the Statutes Act, which states that every statutory instrument shall be published in the Gazette and shall come into operation on the date of such publication, unless a later, or so far as the common law or any statute allows, an earlier date is prescribed in the instrument. So let us pause there for a moment to reflect on some of the histrionics and the misstatements that we have heard here today. A negative resolution does not take effect before the ink dries, as Senator Lakshmi misrepresented here today.
There's nothing she said that was true. Nothing.
The negative resolution is made by the minister. It is laid with the House. It is gazetted. And it is from the date of the gazetting, which is a public notice that the entire world is prescribed statutorily to have notice of, that negative resolution comes into effect. But that is not all. Standing Order 80 of the House of Representatives and Standing Order 78 of the Standing Orders of the Senate provide that the prescribed period shall be 40 days from the date on which the statutory instrument is published. So 40 days from the date of the Gazette, not before the ink dries, but 40 days from the date of the Gazette is the period within which any member of Parliament, be there in the House of Representatives or the Senate, can move a motion which automatically causes the Speaker or the President, the Clerk of the Senate, to bring that motion before the House for debate. So the fiction that we seem to be trying to persuade the world out there that a negative resolution somehow or the other bypasses Parliament and therefore deprives this House, this August House, the Senate, or the other place from a fulsome debate to examine the merits or demerits of that resolution is just so much baloney. With the greatest of respect. So, the point that I wish to emphasize when we look at the amendment that is being represented here today is that, yes, we are asking for the order to be by negative resolution. And the reason for that is because you want it to be expeditious, flexible, and efficacious. You want the order to take effect, particularly in the context of everything that we are talking about today, to take effect immediately so that the process can continue. If we had to come here on the passing of that order and spend the 2 or 3 weeks that we would spend between the House and the Senate, and then possibly back to the House again, it would take that much longer to move the process along, where what we are asking for is a seamless, expedited, efficacious process. And we are asking for a seamless, expedited, efficacious process while still making it subject to the rule of law, the scrutiny of the Parliament. That is prescribed by legislation that has been passed by this Parliament, the Interpretation Act and the Statute Act, and by both houses of this Parliament in the standing orders. So nothing is being bypassed, nothing unlawful is being done. We are following the prescriptive process by which we make laws, and laws are designed in different circumstances to be brought into effect so as to expedite the process where it is in the common national interest to do so. So there's no bypassing. And those who would wish to suggest that there is something unholy or unlawful about the negative resolution process must go back to school and read your law books. Clause 2D of the bill next, Mr. Vice President, proposes to amend Schedule 1 to the Act to reduce the rate of property tax in respect of residential land from 3% to 2%. The effect of this amendment: citizens will now be required to pay less property tax. What is wrong with that? And one of the things I've sat here listening to this debate today, and I genuinely cannot understand the opposition. Mr. President, may I be allowed to speak, please?
Yes.
Members, 51-1, kindly allow the member to make his contribution in silence.
Thank you, Mr. Vice President. I've struggled here today to understand how is it that the UNC opposition is saying that they will not vote for a measure that is designed to reduce the tax. So are they saying that instead of what the government is asking this House to pass, to reduce from 3 to 2%, they want it to stay at the higher level?
Yeah.
It defies explanation. It defies rational explanation, and it is capable of understanding only if you subscribe to any number will play histrionics.
That's what's before us. Yeah, right. Yeah.
It is a benefit that this government after mature reflection, as a representative democratic government, listening to the people, has come back, Minister of Finances to be complimented, has come back to the House to ask for the tax to be reduced. And the opposition are saying, leave it at 3%. They will not vote to reduce it to 2%. It defies logic. It defies rational explanation. It defies the most basic intelligence. There is related subsidiary legislation. The related subsidiary legislation, Mr. Vice President, the property tax deferral of assessed tax application form prescribes a form pursuant to Section 23 for the deferral of the payment of the assessed tax. That has to be read with the amendments that the Honourable Minister has brought here today. And Minister of Tourism has already spoken to the fact that it is being done to enable persons who are impaired by reason of age, impaired health, or other special circumstances. The other order that has already been laid in the Parliament, legal notice number 48 of 2024, is that which, number 52 of 2024, is that which is going to appoint a time period of 6 months after the service of a notice of valuation for the filing of objection to the notice. This order will increase the time for owners to file their objections. Senator Lakshmi allowed herself today to say that the state will take 6 years, so that we're increasing the time, but the state will take 6 years to respond. Section 21 of the Property Tax Act makes it very clear. The board shall, within 1 year of receipt of any notice of objection, consider the objection and may either confirm, reduce, or increase the tax, or make such other adaptations thereto as it considers just. What is this nonsense about 6 years? It is a misrepresentation of the law.
Everything she said was false.
And I just read, Mr. President, from Section 21, subsection 6 of the Property Tax Act, Chapter 76, number 4. There is no reference to a 6-year period. The board must consider the objection within 12 months and determine it. And thereafter,
Senator, yes, no. Senator.
And the further misstatement of Senator Lakshmi, an attorney at law against whom I have practiced. She says that you can be distrained upon whilst your appeal is pending. Again, a misrepresentation of the law. Section 37(1) of the Act says, where any tax assessed under this Act or part thereof is unpaid, the board has served notice under Section 36 and 12 months have elapsed since the same became due and owing. The board may at any time thereafter, before actual forfeiture, etc., authorize the levying of a distress. So the appeal process has to be allowed to complete itself before the board can levy distress. There's no question of distress being levied on whilst the appeal is pending. And she threatened, she said she's going to take the government to court. Well, I will argue the case with the Attorney General.
I come in.
We're talking about ABC law. And the population of this country must not be treated with contempt to assume that they do not understand ABC. Mr. President, Vice President, permit me, and I will not speak for much longer because my voice is going to fail me, which is why, for among other reasons, I will not be distracted to respond to distractions. In summary, the government is moving this House for a reduction in the rate of property tax on residential land from 3% to 2%. The opposition will be voting against this in order to keep it at 3%. Let us understand that. The date for the Board of Inland Revenue next to issue a notice of assessment under the proposed new section 17A is to be extended to June 30th, 2024, if we pass the amendment here today, only for this year, 2024. The opposition will be voting against it to keep the existing deadline of the 31st of March, which is 6 days away.
Absolutely.
Impractical.
That's a start.
The procedure next under Section 52 of the Property Tax Act will be made similar to the Valuation of Land Act, Section 31, to allow for amendment of time periods and therefore a more fluid process. Section 53A of the Property Tax Act will be amended to allow Schedule 1 of the Act to be amended by order subject to negative resolution of Parliament instead of affirmative resolution. I have already emphasized what we are prescribing and asking for is to allow the operation of the rule of law in accordance with the Interpretation Act and the Statute Act and this Parliament in order to allow for expedition, efficacy, and flexibility. Next, the property tax deferral of assessed application regulations will facilitate applications for deferral. Next, the valuation of land appointed time order will increase the time to file an objection to the notice of valuation after 6 months of service of the notice. The opposition will vote against it and say keep the existing 30-day period.
Exactly. Extended from 30 days to 6
I've
months.
never heard anything more impractical, to be quite honest. And I have been in this house, Mr. President, Mr. Vice President, for just about 2 years. And I have sat in amazement at this comparatively new experience that I'm having. But I have not heard more nonsense than I have heard today from the opposition. I applaud the Minister of Finance. I applaud the government, of which I am proud to be part. And with your leave, Mr. Vice President, I support this bill. Thank you.
Reggie.
Senator Leiter.